reported today in The Verge. As Google heads to the Supreme Court, Oracle takes aim at its industry allies. For almost 10 years, Google and Oracle have been fighting over a set of Android APIs, and for almost that long, conventional wisdom has been that the tech industry is on Google's side. But as the case moves to the Supreme Court for the second time, Oracle is taking aim at that idea, and calling out Google's allies one by one. After filing a Supreme Court statement last week, Oracle VP Ken Glueck posted a statement over the weekend assailing the motives of Microsoft, IBM, and the CCIA industry group, all of which have publicly supported Google. Glueck's post comes shortly after two groups, an interdisciplinary panel of academics and the American Conservative Union Foundation, submitted legal briefs supporting Oracle. Both groups argued that Google should be liable for copying code from the Java language for the Android operating system. The ACUF argued that protecting Oracle's code is fundamental to a well-ordered system of private property rights and indeed the rule of law itself. Google has argued that calling its work copyright infringement would hurt software interoperability, saying that it copied elements of Java to support Java developers building apps for Android. Earlier this year, it garnered around 24 briefs supporting its position. But Oracle claims that in reality, Google appears to be virtually alone, at least among the technology community. Glueck says Google's most prominent backers had ulterior motives or parochial agendas. Either they were working closely with Google, or they had their own designs on Java. Microsoft, for example, settled a Java-related lawsuit with some parallels to Google's case. That was, granted, nearly 20 years ago. Oracle alleges that IBM simply wants easier access to Java after acquiring software company Red Hat. And Google is a prominent member of the CCIA. Glueck also argues that these briefs don't support Google as wholeheartedly as they seem. It cites Microsoft's brief, for example, as only addressing one of Google's two arguments for why its borrowing is legal. That argument involves establishing Google's actions as fair use, though, which would still be enough to get it off the hook. It's not all that surprising if Microsoft and IBM are filing briefs because a ruling for Oracle could hurt their business, rather than because it offends their principles. Oracle takes things a step further and suggests that Microsoft is acting in outright bad faith, saying that it only started defending Google because of a 2015 partnership. Glueck notes that Microsoft was once among Google's strongest antagonists as a point in Oracle's favor, although it's a somewhat ambiguous fact. Google has argued that having support from a major rival proves it's got a point. Even if you accept Oracle's. For more on this story, visit the news article link.